Article 2. Sexual Crimes Against Decency and Morality. Chapter 60. Adultery. Section 761. Definitions. At common law, adultery was merely a civil wrong and consisted in sexual intercourse by a man with another man's wife. At Roman law, this was a crime, both man and woman being principals. The crime was against the rights of the husband, and the tendency to adulterate his issue. Neither at common law, nor under the Roman civil law, was it an offense for a married man to have intercourse with a single woman, since this neither violated a husband's rights to his wife's person, nor could force spurious issue on another. Under the ecclesiastical law, adultery is sexual intercourse by a married person with anyone other than the lawful husband or wife. The crime is statutory in this country, its elements varying with the different wording of the statutes. Some statutes follow the ecclesiastical law, and both man and woman are guilty. Others follow the ecclesiastical definition, but make only the married party guilty. Others adhere strictly to the Roman rule. If the statute merely defines the crime as adultery, then, Wharton says, it means sexual connection between a man and a woman, one of whom is lawfully married to a third person, and both are principals. Section 762. Elements of offense. What must be proved? There must be evidence of a valid marriage of one party, the requirements and proof of the existence or termination of which are the same as in bigamy. It is unnecessary to prove emission in adultery, the rule being the same as in rape. Intercourse should be proved, but this may be done by circumstantial evidence, as occupying the same bed, living together in the same room for some time, or evidence of cohabitation and birth of children. Evidence of previous improper familiarities is generally held admissible, and sometimes evidence of subsequent familiarities or intercourse. Admissions and confessions may be used in evidence, both as to adultery, or as to prior marriage, for what they are worth. Intent is an element, but may be inferred from the act. Insanity or a mistake of fact, on the part of one party, may tender that one innocent, though the other is guilty. So where a woman supposes herself legally married, she is not guilty of adultery because the marriage is void, on account of a prior existing marriage of the man. Section 763. Defenses. Divorce is a defense, as in bigamy. A divorce which does not give the right to marry again is a defense in adultery. An honest though erroneous belief of the defendant that he had been divorced is no defense. Also it is held that ignorance by the man that the woman is married is no defense if the intercourse was illicit. Nor is a morganatic marriage a defense. Acquittal of one defendant is not a bar to the prosecution of the other. But where one person marries another believing on reasonable ground that such other is unmarried or that a prior spouse of the other is dead, a prosecution for adultery is barred. Acquittal of one party is not a bar to a prosecution of the other. Section 764. Witnesses. The one with whom the defendant is alleged to have committed the offense is a competent witness for either prosecution or defense, but as an accomplice such testimony must be corroborated. At common law, neither husband nor wife could be a witness for or against the other in a prosecution for adultery. Section 765. Complaint of husband or wife. Under some statutes the prosecution may be heard only at the instance of the spouse of the married participant, the offense being considered as primarily against the husband or wife, and the fact that the prosecution was begun by the injured spouse must be proved by the state. Such party may withdraw the proceedings and the prosecution may go no further. But once begun by the spouse, it is unnecessary that such spouse cooperate further, and the court may carry on the proceeding. If such spouse has been divorced before the proceedings, there is no right to prosecute, but a divorce after the proceedings are begun cannot affect them. Section 766. Conviction of other offense. It has sometimes been held that if there is a failure of proof of marriage of one party, there may be a conviction for fornication. If the evidence shows a lack of consent of the woman, it is sometimes said the crime is merged into rape, while in other cases it is held the state may elect as to the offense. Section 767. Living in adultery. Illicit cohabitation. The foregoing discussion has been confined to cases in which proof of a single act of intercourse is sufficient to sustain an indictment. There are some statutes which punish the offense of living in adultery, that is, where a man and woman, not married to each other, live together openly and notoriously as if husband and wife. The theory of such statutes is that there is no offense to the public in illicit intercourse until the element of indecency and public immorality enters. It is usually held that living in the same habitation together is necessary to a conviction under such statutes. The contrary is also held. A single act of illicit intercourse does not constitute this offense. There must be continuous living together. But a single act may be sufficient if there is also cohabitation, and living together adulterously a single day may be enough. Clandestine, though continuous, acts of intercourse do not make the crime, for it is open and notorious living together which constitutes the offense. Under some statutes, however, it is no defense that the intercourse is secret, or mere habitual illicit intercourse is made adultery. Under these statutes it is not necessary to the offense that either party be married. Section 768. Attempt to commit adultery. In some states where both parties may be convicted for an adulterous act, solicitation to commit adultery is punishable as an attempt. The better rule seems to be that it is not an attempt, not an overt act leading to the crime, and is not indictable. Especially is this true where the one who solicits is unmarried and under the statute incapable of committing the offense. Section 769. Presumptions. Burden of proof, weight and sufficiency. It is not essential that the state prove that the alleged adulteress spouse was living at the time of the offense charged. Proof that he was alive within 1 year prior thereto sustains the rebuttable presumption that he still lived. The fact of commencement of the prosecution for adultery by the wife of the defendant is not such an element of the crime charged as to require proof thereof beyond a reasonable doubt. A preponderance of the evidence will suffice. Where there is evidence that at the time of the offense accused was married to one other than his alleged paramour, a variance between the allegation and evidence as to the name of the wife of the accused is not material. The act of adultery may be established by circumstantial evidence. Evidence of illicit conduct prior to the 2 years has been competent in corroboration. Evidence merely of the disposition of the accused to indulge in the act of sexual intercourse and opportunity to do so are not sufficient to sustain a conviction. The indictment need not allege the name of the spouse of the accused. Even if the name is alleged, it may be treated as surplusage.